Okay, we're going to start this module on Canada, a legal history lesson. And I hope in time we get to the right one. So it's a legal history lesson. In Canada law, moral boundary are not synonymous. Everyone's interpretation and reaction to law is different, so moral boundary can differ. There is quite a web of categories of law in Canada. Substantive and procedural are two main categories. Substantive being limits on conduct and procedural being how they are enforced. These two can be broken down into either public or private law, public being constitutional law and how the country is governed in relationships between citizens and country, private being personal, social, and business relationships among the public. In Canada's jurisdiction, it was a bijuralism at first, meaning two jurisdictions coexisted in the country, French civil law and common law legal system originating in England. In the province of Quebec, French civil law segregated a list of rules stated in broad principle. Judges used to apply a case before them, and prior decisions do not constitute binding precedents. In the rest of Canada, there is a local court enforcing customs and traditions, originating in England. Both of the above are redistricted to a thing called stare decisis, making the judges follow precedent binding to all lower court systems and allowing parties to predict outcome of litigation. Common law had limitations due to restriction from stare decisis, so the Court of Chancery was appointed to rule cases not handled by common law. Parliament in Canada is seen as having supremacy statutes cases and where the two conflict, statutes and legislations prevail. Courts cannot overrule Parliament, and Parliament cannot pass a law that future parliaments cannot change. It's really a long way from what it used to be nowadays, though, because of all the stare decisis and the POGG sales in Canada. Business law around sales and consumer protection is held in the Sale of Good Act in Canada. This act deals in the risk of sale and exchange. In a common sale, there is both title and risk. Title being ownership of property, and risk of sale is in regards to whom is losing and who is to gain. Now, provincial legislation flips and fills a gap when a contract fails to imply a good or service measure in retail, consumer, and commercial transaction. Fails to imply a good or service measure in retail consumer transaction. But this will not apply to real estate or services. Installation of goods still apply, though. For example, winter tires, title of goods must be transferred for the act to apply. If it is not a sale but a securing of a loan, the Sale of Good Act does not apply unless security is part of the transaction. Also, Sale of Goods Act does not apply to barter unless money is exchanged. Contracts. A transaction is considered a sale when the title is transferred immediately. An agreement to sell is when a contract can stipulate. Business law in Canada has varied contracts under sections of Incoterms, CIF, FOB, and COD. Incoterms, International Chamber of Commerce, or ICC, is an increment international movement of product over time. CIF contract is paying for insurance and freight. FOB is free on board contract and only pays for the cost of the product. Meanwhile, COD contracts are cash on delivery and you receive before you pay. Pretty simple methodology there. Courts. The Charter of Rights and Freedoms in Canada has many legislations and sections within. In 1867, it was the Constitution Act. This act was similar to the United Kingdom Magna Carta Bill of Rights and protections of citizens from arbitrary actions of government. In 1882, the Charter of Rights and Freedoms placed some limitations on supremacy of Parliament. In sections 91 and 92, it legislated federal and provincial jurisdictions of many areas. Section 91 divided federal and Section 92 divided provincial areas. The Peace, Order, and Good Government Act. Peace, Order, and Good Government gave federal residual power to make legislation and creation of statutes not included in the Constitution. This had jurisdiction in three main groups: legislative, judicial, and executive. The federal parliament supremacy legislation actions like statutes had an executive prime minister, cabinet minister, and civil servant bureaucrats. The judicial had premier, individual provinces and territories interpreting legislation and managing case law. Both had jurisdiction implementing law in their own sector. Provincial bylaws, for example, were taken to premier jurisdiction, where they are implemented municipal. And federal statutes were jurisdiction federal through Parliament and Prime Minister. Dispute resolution, as is, the disputes can be resolved in a few ways. It's not always necessary to bring it to courthouse level. Alternative dispute resolution, or ADR, is an alternative litigation. Alternatives to litigation are optional, but most of the time both are good problem solver and useful in furthering your case in courtroom. 3 ways you can do ADR: negotiation, mediation, or arbitration. Negotiation is an agreement between 2 private persons or businesses that is both agreed upon and implemented in both parties. Though not binding, negotiation is usually a verbal contract. The method at hand, those with a dispute. Mediation is, on the other hand, bring third party to the dispute with neutral opinion and sides of the dispute, giving an attempt on agreement. Also not binding. Arbitration is a written contract between both parties to form contract between actions of either party. Arbitration is binding and does have a lot of merit in the courthouse. On bringing a dispute to court, most private matters have been through ADR, small claims court, and provincial level. The guilty sentence is found or not found in a criminal trial, but the sides of a dispute and the court's play referee is what a civil claim is, essentially. Larger disputes, like things over $35,000, start at superior court level, though if a dispute is worth less than $5,000, it starts at the provincial courts. Drug treatments, domestic violence, mental health courts, small claim courts. Torts and crime. Torts and crime. A lot of regulations and legislation revolve around crimes. Crimes are civil wrongs that affect society as a whole. Most civil and social wrongs are under tort law, not crime, but a wrong can be both crime and tort. In the next few chapters, I will be going over the various torts impacting businesses in my textbook, so you can look into them in the PDF file attached to this module. A tort is a social or civil wrong that gives rise to the right to sue or seek remedy when the intentional or careless act of negligence harms another. Tort law compensates victims while at the same time educating the society. Tort law is constantly evolved, so at the time I publish this, you might slightly differ and find our details. Tortuous activity is inherently wrongful conduct. Torts have vicarious liability, i.e. employer to employees. Fault. With the courts on tort law, a balance of probability is standard of proof in small civil claims court. Intentional torts are intended or deliberate as opposed to inadvertent. Defendant does not need to intend harm. Some examples of intentional tort are trespass on person, trespass on land, trespass on chatels, conversion, and detinue or false imprisonment. For more information on these, it is in the textbook PDF attached to this module. Court system map. To become familiar with the Supreme Court of Canada at the top, underneath are the Court Martial Appeal Court, the Provincial Court of Appeal, and the Federal Court of Appeal. Below them are Provincial Territorial Superior Courts, or Federal Court, Final Division, and the Military Courts. To the side is a Tax of Canada Court, and the very lower levels are Provincial Courts, Provincial Administrative Tribunals. What you're looking for in a common civil claim would be the provincial courts, and many tribunals within them for certain cases, like landlord-tenant disputes or business interactions from time to time. End of module video.